Scott Pruitt is in the News Press's studio today to talk about law in Oklahoma. Welcome to Stillwater.
It's good to see you, Chris.
Good to see you too.
Start of the football season is exciting.
Yeah, can't beat that.
Yeah.
We're always looking forward for a good season for Oklahoma State and even our rivals down in Norman.
Because you're magnanimous, right?
That's right.
Yeah, that's good.
Well, we want that last game of the season to be for the Big 12 championship.
Well, that'd be good.
You're in town today to talk with the Payne County Bar Association. I'm glad you stopped by before that to talk to us a little bit about what's going on with you in the Attorney General's office.
Well, thanks for the hospitality.
And I wanted to start first with the Affordable Care Act. And the state has challenged the legality of the Affordable Care Act, specifically the Internal Revenue Service's ability to fine large employers who refuse to provide the employee insurance in states that have opted out of establishing the state-operated health insurance marketplace. So where do we stand on this now?
Well, there's actually two decisions under the Affordable Care Act that states have a responsibility to make, one of which actually only came as a result of the original Attorney General lawsuit, which is the decision that Chief Justice Robert issued last year on Medicaid expansion. Before the attorneys general from across the country brought the initial lawsuit back in, after the law was passed in March of 2010, the states were forced to expand Medicaid, and Chief Justice Roberts said that violated the spending power of the Constitution. And so the decision that Governor Fallin and the legislature has been about on Medicaid expansion only exists as a result of the original lawsuit. Now, this particular lawsuit is about implementation of the law, not the constitutionality of it on its face, but as the IRS is implementing the law and enforcing the employer mandate penalty, they are limited to doing that only in states that have a state healthcare exchange. That's not my opinion. That's not editorial comment. That's what the law says. That's Section 1401 of the statutes. And so when the IRS passed their rule last May to say that they were going to enforce the employer mandate in all states, whether they have a state healthcare exchange or not, that violated the statute. Oklahoma we had a case in Muskogee. We amended that case and brought the action against the IRS. So where we are in the litigation is the federal government challenged Oklahoma's ability to bring the lawsuit. The court said that we had the ability, the standing, to bring the lawsuit, and now we're going to proceed to the merits on the statute and whether the IRS acted outside of the scope of the statute.
Now, has there been a court date set for the?
Not for the second round. I mean, there was an oral argument that took place on the standing issue. That was back in June. And then the ruling came in July-August timeframe. So that just recently happened. Very important case.
Would we anticipate that it would happen before the end of the year, or are we looking
it's
at
very
2014?
It's very difficult to know. I mean, the court's docket is such that, particularly in the federal court, it's very difficult to determine how quick that will occur. But it's a very important case. I mean, 34 states across the country have chosen not to set up a state healthcare exchange. And so Oklahoma, if we're successful in this litigation, where the IRS will not be able to assess the employer mandate tax because of the state not setting up a state healthcare exchange, then the precedent will be set. And the very structure of the Affordable Care Act would be called into question.
And this is more about legalities and not just being against the policy.
That's right. I mean, it's an implementation issue. I mean, many have said, isn't this all settled? I mean, the Supreme Court decision from last June, didn't that settle all the issues related to the ACA and its implementation? And the answer is no. I mean, the Hobby Lobby case that we know about, that we were actually a part of in an amicus fashion before the 10th Circuit, that's dealing with the Health and Human Services Agency. The IRS has responsibilities on the law as far as implementing it. What's important is that they implement it consistent with the statute as drafted by Congress. Here the IRS has disregarded that. They've simply said, look, whether the state sets up an exchange or not, whether that's reserved to the state or not, we're going to do this. We're going to assess the employer mandate tax in all 50 states. And that's just not consistent with the statute. I actually testified before Congress about a month ago, and the Government Oversight Committee was on the panel with other attorneys from D.C. talking about the plain reading of the statute and how the IRS, the agency, had exceeded its authority. So this goes to implementation. It's not a policy statement. It's not politics. It's literally rule of law and what authority the agency has, in this case the IRS, as it implements the law.
Okay, that sounds good. And another case that we are involved in involves the EPA and the emissions by the coal-fired plants, and that's also an implementation of the law issue
It
as
is,
well.
Chris. I mean, you're exactly right. I mean, it's an issue. The EPA is responsible with the state of Oklahoma and other states across the country at adopting, that the state is responsible for adopting something called a state implementation plan to improve visibility in certain key federally designated areas. In our case, it's the Wichita Mountains. And it's called the Regional Haze Statute or the Regional Haze Rule. And it is what it sounds like. It's aesthetics. It's trying to improve regional haze to make sure that natural visibility is reached by the year 2064. Well, almost 4 years ago, the state of Oklahoma adopted a plan, beat that deadline by almost 15 to 20 years, and so we did everything we were responsible to do under the statute, and the EPA didn't like it. The EPA didn't like it because they recognized that we still had fossil fuels that we had in our plan, and they didn't want us to have the burning of coal and other fossil fuels, so they came into the state in 2011 and tried to reject our plan, inconsistent with the statute. And so our lawsuit is about that: what authority the state of Oklahoma has, what authority the EPA has. And under the statute, it's very clear. The state has primary authority, and that's congressional, both the legislative record as well as the plain reading of the statute. And the EPA has disregarded that. So that case is before the 10th Circuit. I argued that case back in March in Denver, and we're hopeful that we'll have good outcomes ultimately on that case. We're trying to get the entire 10th Circuit to look at the issue.
And what are the prospects of that? How does that work?
Well, there's a petition that we file with the court. We'll file that no later than September 3rd that asks the court en banc to hear our appeal. And it's rare for the entire court en banc to hear an appeal. Generally, it's a 3-judge panel, and that's what I argued in March of this year. We're going to file that petition in hopes that they find it compelling. I think in this case they might, because this issue affects other states. It's not just Oklahoma. There are a lot of states to our west, Colorado, New Mexico, that are dealing with similar issues, where they've taken responsible steps. They've done exactly what the law requires. They have balanced the interest. And one thing I want to mention, Chris, about regional haze that is different than other environmental laws, with regional haze, because it's about visibility and not health, it's about aesthetics and not health, the state can engage in something called a cost-benefit analysis. So it can look and say, look, if we invest this amount of money and we improve visibility by, in this case, 1 deciview, that's a balancing that the state is authorized to engage in under the statute. Here the EPA disregarded that. Here the EPA came in and said that balancing that the state of Oklahoma conducted, they didn't like the outcome, and consequently they wiped the slate clean and tried to force a federal plan upon the state. That federal plan was estimated to cost back in 2011 roughly $2 billion that PSO and OG&E would have to pay to comply with the federal plan that was inconsistent with the statute, and it would have caused utility rates to go up 15 to 20% annually within 3 years. So that's a substantial cost to consumers across the state. It's a substantial burden that is not consistent with the statute, and because it affects other states, and because this is a case of first impression, it's possible, more likely, that the entire court en banc would hear that case. We'll see. And if they don't, I mean, I think there will be potentially an appeal to the U.S. Supreme Court on the issue. But that's a little bit premature to get into.
Okay. It seems like Oklahoma is taking the lead in a lot of cases or instances where the federal government seems to be overstepping the legalities of the enabling legislation. Is that something that's been a focus for your administration?
Well, I think there's ebb and flow historically about the relationship between the federal government and the states, and I think over the last 3 or 4 years at least, it's definitely been more flow than ebb as far as the way that the feds have responded to the states. And again, it's important to note that with environmental laws, President Nixon set up the EPA in the early 1970s. The Clean Air Act was passed in the 1970s. Congress was very purposeful from the very beginning of saying that states were an important partner under cooperative federalism to help implement and enforce the environmental statutes. And so these are not matters that we are looking at trying to create a state purpose or role. Congress has recognized it and been very specific about it in the statutes. What we're dealing with, Chris, here is at times anyway, a complete disregard, an utter disregard for what the statutes actually say. And I think people are recognizing that across the country. When you have the President of the United States say that he can't wait on Congress and that he's going to instruct agencies to do certain things outside of congressional authority, that should concern us all. Whether it's dealing with the EPA or the IRS or the Health and Human Services or whatever agency it is, because that causes our framework to actually fall and be dysfunctional. And that's what I'm concerned about. This is really about rule of law. This is really about giving meaning and flesh and life to the statute as drafted by Congress and making sure that the balance between the federal and the state government, in this instance, and the implementation of environmental laws, is maintained and secured. There's a way that it can be fixed. I mean, if the EPA wants to usurp the state's role, they can go amend the statute. They can go to Congress. There's a way to do that. What they're doing is doing it outside of the normal processes. And that's a concern as it relates to rule of law.
Okay, sounds good. Let's talk a little bit about the Keystone XL pipeline. You recently joined with about 20 other attorney generals from across the nation to encourage John Kerry, the Secretary of State, to go ahead and get the permit passed on this. How did we get involved in this, and is this another rule of law issue?
Well, there's a place down the road from us here that's a pretty important place. It's Cushing, and Cushing is a tremendously important hub. And there was a concern 2 to 3 years ago that there was actually a glut of oil that was occurring in Cushing, and that the transportation issues south and north, that perhaps it was causing some market-based conditions that concerned both the consumers and industry. So Cushing is a tremendously important factor in the analysis of the Keystone Pipeline. And so we actually made a record. Secretary of State Hillary Clinton was in the state. Chris, I can't remember the exact date, but it's been a couple years ago, when the initial consideration by the president was occurring. We filed comments when she was here. There was actually an open meeting and proposed rulemaking that was occurring at that time, and we made comments on the record. And then the decision was made, I think wrongfully by the administration, not to have the north portion of the Keystone built. There were some issues in Nebraska. My colleague up there, John Bruning, who's the Attorney General, the governor of Nebraska as well, they had to reroute the Keystone a little bit up in Nebraska. That's been addressed. So when you look at the states that are affected here, from the Canadian border and all the way down to the southern border, obviously it's important Oklahoma from a jobs perspective, but also the Cushing component. There's alignment. And so you got to step back and say, why isn't this being granted? And unfortunately, I think it's politics. Economically and from an energy perspective, it makes abundant sense to grant this permit. Great environmental concern has been taken into consideration by all the states and by the federal government. It's taken longer to consider this perhaps than any other pipeline that's ever been proposed. And you've got a source of energy up with the sands, the tar sands in Canada, that it's going to go somewhere. And so while we aren't taking advantage of that as a nation, there can be no other explanation but that it's politics. And so I wish that the feds and the purpose of the correspondence with the other attorneys general was to send a message to the federal government: quit playing politics. Make a decision that's best for the country in providing energy to this country long term. We imported less than 42% of oil last year, which is a good thing. That's the right trajectory that we want to see. Let's get serious about energy independence, and this is a big part of it. So I'm not sure what the delay is other than politics, but they need to be adults and more mature in Washington and get this thing approved.
Okay, sounds good. Can we talk a little bit about the Open Records Act?
Oh, absolutely,
Open Meetings Act?
absolutely.
Recently the Tulsa and Stillwater police departments have denied records requests because of officers who have committed either a felony or misdemeanor crime and who have submitted resignation letters. What do you do, or how do you work with the governments and public to ensure that they know what the laws are?
Yeah, there are a couple things that I think are important to note. One, the Open Records Act, as you know, Chris, is everything is open under our laws in the state of Oklahoma under the Open Records Act, except those things that are particularly exempted or accepted in the statute. So it's a general policy that says everything's open unless we specifically say in the statutes it's not. And so in these kind of cases, what the evaluation is whether there's an exception or an exemption in the statute that would prevent or that would instruct the local police departments not to release that information. Now, there is a section I know of in the statutes that talks about internal personnel investigations. I've not looked at the facts of the cases that you're referring to, so for me to be able to put it in that or not is not something I can give an opinion to at this point. But that would be the evaluation. The process is, in response to something like this, is it generally goes to the local district attorney to look at, to evaluate whether there's a proper exception or not. And at times we're asked, in the AG's office to issue a formal opinion, which we've done. I mean, as you know, last year we issued an opinion on mugshots and said that those were considered and are, in fact, open records, and there wasn't an exception under the statute. So we get those kinds of questions, Chris, and evaluate them properly. But even beyond that, we work proactively with municipalities, boards, and commissions in helping implement the law. We actually have Jan Pressler in my office, others that go out with agencies of state government as well as boards and commissions and municipalities at the local level to educate them. We have seminars and on here's what it means to comply, here's how executive session and the rest, how all that works. And so we're trying to educate and be proactive about that. We have those multiple times throughout the year. So it's both proactive and educational, and then there's a process postscript if there's a question.
Okay. You recently announced that you're going to run for re-election.
Huh?
Why did you make that decision, and what do you think are going to be the big campaign issues?
Yeah, I mean, there could be no more consequential time to be serving as Attorney General than right now. I mean, you asked me about the Keystone Pipeline, the EPA with regional haze, which affects consumers, the Affordable Care Act, and the public safety issues, workers' comp fraud. These issues that we deal with on a day-to-day basis are very consequential and impactful issues. We're able to represent and actually help people on a day-to-day basis. The mortgage settlement that we negotiated 2 years ago, where you had certain loan servicers that were abusing homeowners and dual track and fraudulent activity through the foreclosure process, negotiated an $18.6 million judgment for Oklahomans, where we've been helping them be compensated for those wrongful acts. So that is something that impacts people in a very personal and meaningful way. And to be able to do that day in and day out, it's a great place to be and a great place to make a difference. Very thankful to be serving right now as Attorney General, and prayerfully we're making the impact that we all seek to, and hope I can do that in another 4 years.
Okay. Is there any other issue that I haven't brought up that you want to talk about?
The only thing I would mention is I mentioned in passing the workers' comp fraud, and obviously we've seen some changes at the legislature this year on our workers' comp system. Our fraud prosecution in the Attorney General's office for the last 3 years is up 62%. So for every dollar we've invested in fraud prosecution, we've got $6 back into the system. And so we've been very intentional with all these national cases we're involved in, Chris, that you cited. We're still doing and making sure that the focus of the office is in the fundamentals as well. Comp fraud, litigation representing the state, general counsel, and helping agencies. And we're seeing the benefit of that in areas as important as workers' comp fraud.